So I wanted to make a video for you guys dealing with Rule 401, relevance, and I want to preface this with this is really for law school students, helping them understand the rules of evidence, specifically relevance, and I think this is a really important subject matter because anytime you have evidence, the first conclusion you're going to want to make is whether it's relevant. And later on down the road, you're going to have to deal with admissibility, but really the first determination is it relevant? And this is more than likely something your professor is going to test you on specifically, and they'll give you a set of facts, and you'll have to determine if it's relevant. And so you're really going to want to have a firm understanding of this. And later, you'll make determinations whether it's admissible under, 104 B or 402 or whatever. But as with everything, you first look towards the rule. So Rule 401 states evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. So this is a two-part rule, and before I kind of move on, I want to hone in on a couple of different factors. So the first being this sentence right here in Part A, it has any tendency to make a fact more or less probable, and specifically any tendency. So this language is constructed very liberally in order to ensure that the most amount of evidence is able to be presented before the court. So basically, I mean that they phrase this so that it would be an extremely broad and liberal interpretation of the rule. So any tendency is basically evidence it doesn't have to prove anything conclusively. It only has to have some tendency to make a fact more or less probable. And that tendency can be very, very low. It can be minute tendency. It barely, and it would still have any tendency to make a fact more or less probable. And this part right here, a fact more or less probable is what we would call probative. Is the evidence probative? Does it have any tendency to make a fact more or less likely, right? And then going into part B, the fact is of consequence in determining the action. So is this important to what we're trying to figure out? And this is what we would call is it material? So there's kind of two parts. Is it probative and is it material? Part A, part B. So while probative is the first part, A, it tends to prove or disprove a fact. Part B, whether it's material, is if it bears on a fact of consequence in determining the action. That's going to depend on the issue and the substantive law. So really, if actually, why don't we move on to this awful graph that I made in Paint, and hopefully this will help me kind of flesh out some of those details. So here we have our evidence, and let's say that the evidence is a testimony of a gentleman who works at an auto body shop stating that the defendant came in and asked for their car to be painted white, and that, and then they painted the car white. So the fact is that we're trying to prove is that the defendant had a white car, right? So is it probative? Your first part A, yes, it's probative. So, okay, so why do we want to prove that he had a white car? Well, the issue at hand, let's say, is that a victim was hit by a white car and there was paint on her vehicle that was white. And so, okay, so is the fact that he drove a white car material? Is it important to the action whether he hit her or not, right? So I would say yes, it is important, it is material, and then therefore it would be relevant, right? It has the testimony has any tendency to make it more probable that he drove the car and that he was the one who hit her, right? So in this chain, what we have is inferences, right? So does the testimony that his car was painted white make it more or less probable that he drove a white car? And you have to do you have to be able to make that logical jump from A to B. Does someone who asked to have their car paint, are they generally the driver of the car? And you could say yes, or you could say no. It could say, oh, no, it doesn't. But in this case, I think it obviously does. So, and the fact that he drove a white car, why is that important, right? Because we're not trying to necessarily prove that in this piece of evidence that he hit her. We're trying to prove that he drove the white car. So that's probative value. It doesn't have to prove conclusively anything. It just has to make it more or less probable. So in that specific case, it's important to the action we're trying to determine. Another case, you could think of would be, all right, so the defendant, let's say that there's evidence that I don't know, the defendant yelled out something violent to a person in a parking lot, right? And they want that person to testify. And the action here is let's say it's murder. Let's say he's on trial for murder. And so the evidence is testimony that he was said something crazy in a parking lot to some other guy. Now, I want you to get it out of your head because this might not be admissible under some other rule, but just ignore that for now. So is it probative? And does it have any tendency to prove the fact, to prove a fact? And maybe the fact that we're trying to draw upon here is that he did say that, and then we want to make an inference from here to here. So is testimony make it more likely that he did it? Yes, I would say that there is some probative value there. There's some tendency that it does make that fact true, right? Now, is it material? So this is another chain of inference. Like, you would have to be able to say that, well, someone who's violent or has violent tendencies, or someone who yells at another man in a parking lot something violent, is more likely to have violent tendencies, and someone with violent tendencies is more likely to commit a crime, and a violent crime, and murder's a violent crime, and so it makes it more likely that he committed the crime. So you kind of run through this chain of inferences getting from point A to point B. That's probably not a really good example. There could be problems with that. But essentially, your evidence doesn't necessarily have to prove that he committed the murder. It doesn't have to be the murder weapon. It can be, evidence he purchased bullets of the same caliber as the gun. And, so then you can say, well, defendant owned a gun that was the same caliber as the bullets fired in the murder. And is that important? Is that material? Does that make, is that of fact of consequence in determining the action? Yes, it is. And so that's how you kind of make that jump from here to here. And it's important to be able to explain your inferences, and especially to a law school professor. And again, this is something that the trial judge will make a determination on its whether it's relevant or not, and then it's up to the jury to decide the value they place on that evidence. Some things are very low on the probative scale, and other things are very high. So the jury can make a determination whether they think that that's important or not if it's admitted. But again, the trial judge, this is a liberal construction, so he has reason to, he has reason to allow a lot of things into evidence, as long as they're probative, as long as they make a fact more probable and they're material to the cause. So I'll try and give you an example, and this will probably be a bad one of something that might not make it through the relevance test. So let's say that evidence that a defendant bought socks the day before, you know, the day before the murder, right? And it's not. Let's say it's not important to the timeline. It's just that he bought socks. Okay, well, what's the inference or they're trying to make? You know, what's the probative value? And the trial judge is going to say, like, listen, that doesn't matter to the action. Like, the fact that he bought socks bears no weight on whether this gentleman committed a murder. It doesn't go to prove anything. It doesn't go to prove a fact that would be material to our case here, and therefore it's not relevant and get thrown out there. So that's a really that's a really bad example, but it's an example, and it kind of shows you that your inference chain needs to be good, because someone who's very crafty can make an inference chain that leads across the board and get things in that might not be important. But let's for example, let's do one other one real quick. Just another bad example. Okay, so let's say that the prosecution seeks to admit defendant's pay stubs, how much he's getting paid, right? And he's on trial for murder. Okay, well, you can go through this chain of inferences and say, well, why does it matter how much he got paid in concluding this murder? And if the prosecution doesn't have a good chain of inference, if they don't have a reason, it won't be admitted, because it doesn't seem to have any probative or material value to the action or issue at hand. However, if, let's say, the prosecution said the the motive was a financial gain for the defendant, that he was in the will, or that he was to be a primary beneficiary of some sort of benefit package, then showing how much he made might go to say, well, the defendant didn't make enough, right? So you would want to have admit evidence in that he was in some financial trouble. Does this salary make it more or less likely that he was in financial trouble? And if he was in financial trouble, does it make it more or less likely that he would murder this person to receive their benefits, right? So then in that chain of inference, we can see that the evidence has some probative value to prove the fact that he wasn't doing well financially. And it's material because of the motive that they've offered, and that is that he murdered her because he needed the money, or because he wanted the money. So that kind of explains how something can go from relevant and or not being relevant to being relevant, and vice versa, and how someone who's crafty can figure out to draw the lines. I mean, for a law student, the facts are the facts you're gonna be presented with. You can't necessarily make up facts to make something relevant, but if it's in there, you want to look for it. So you definitely want to be able to have those chains of reference, chains of inference, going from point A to point B, and across the line. So I hope this was a little bit helpful. It certainly was for me. And if you have any comments or suggestions, or if you thought I made a mistake, or I'm looking for feedback as well. I'm trying to learn this stuff, so I hope that I provided some value to you guys. But I'm always looking to improve. So if you've done it a different way, if you understand it a different way, if you have a hypothetical that you want to run by and we can discuss it, please leave it in the comments below, and feel free to message me, or leave a comment if I can help you. And yeah, good luck, everybody.